All right, y'all, we back again, man. So the city of Galveston responded again. So to remind you, let me refresh y'all. They asked for clarity on my date of birth. So I sent that in. Then they had 10 days to reply, and they replied last night, along with the DA's office. So we got a lot to recover, man. We got a lot to go over. Let's just go ahead and get into the letter. So it says the city has reviewed its files and has located responsive records to your request. So what's that saying is they didn't say, however, they didn't go to the AG, right? Keep that in mind. They didn't go to the AG, mind you. They didn't go to the Attorney General to try to get to withhold records. So their letter said the information you requested contains one or more exceptions to public disclosure listed below. Our office is prohibited by law from releasing this information to you, and therefore we have removed this information from the information we are providing you. Number one, credit cards, debit cards, charge cards, or access device number collected, assembled, or maintained by or for a governmental body. It's confidential under section 552.136 of the Texas Government Code. Cool. Basically saying they took stuff out without having to go to the AG. And it says information that relates to a motor vehicle operators or driver's license or permit issues by an agency of the state or another state or country, or a motor vehicle title or registration issued by an agency of the state or another state or country, or a personal identification or document issued by an agency of the state or another state or the country or a local agency authorized to issue an identification document. Confidential under 552.130 of the Texas Government Code. Number three, information that relates to a peace officer, county jailer, a current or former employee of the Texas Department of Justice, a commissioned security officer, an employee of the district attorney, criminal district attorney, or county or municipal attorney whose jurisdiction includes any criminal law or child protective service matters. An officer or employee of community supervision or corrections department, a criminal investigator of the United States, a police officer or inspector of the United States Federal Protective Service, a current or former employee of the state of Texas, of the state of the Attorney General who is or was assigned to a division with law enforcement duties, a federal judge or state judge, juvenile probation or detention officer certification, certified by the Texas Juvenile Justice Department or its predecessors, an employee or juvenile of the Juvenile Justice Program or a facility, or a current or former employee of the Texas Juvenile Justice Department or its predecessors. It says a public employee, home address, home telephone number, emergency contact information, date of birth, social security number, and or family members' information as allowed by section 552.11157 of the Texas Government Code. This public employee has chosen to make this personal information confidential. The home address, telephone numbers, emergency contact, social security, family member information of the public employee or officials as allowed by section 552.024. I know it's a little boring, but I'm just trying to get through it. This public employee or official has chosen to make this personal information confidential. Normally, we must request a ruling from the Texas Attorney General before we can withhold any of the information you requested. However, the Texas Government Code allows us to withhold this specific information without requesting a ruling from the Attorney General. Keep that in mind. Why did they do that, and why the DA couldn't do that, and why DPS just couldn't do that, right? It says you have the right to appeal our decision, to withhold information from you. Instructions for appeals are at the end, right? Simple as that. So they replied pretty much whatever they want to redact, they're going to do that. Whatever they're going to take out, they're going to take out. Anything that they're taking out is pretty much by the law. Again, that's nothing that I care about. We don't take it out. We just want Stephen Adams Vincent on the platter. That's what we want. So let's get into the breakdown of the clarification of the letter. So it says, good, this is your first actual production with redactions. Again, and it is important to understand what this is and what this is not. What this letter really means. This one is from the city of Galveston, not the DA's office, not the DPS crime lab. So this likely came from the Galveston Police Department, GPD records. They are saying, we are giving you records, but we remove certain personal sensitive information that the law allows us to automatically redact without asking the Attorney General. Cool. That's what they redacted looks like. Look at the categories. They listed routine personal information, credit cards, access device numbers, driver's license numbers, vehicle registration, personal ID numbers, government employee personal info, home addresses, telephone, date of birth, social security numbers, emergency contacts, family members, information, law enforcement, such officials, safety info, information tied to peace officers, DA employees, judges, federal investigators, probation officers. This is normal redaction. Says these are the exact kinds of things the Texas government code let the government code lets, it's weird how they put this, lets agencies withhold without asking the Attorney General first. And importantly, these are not DNA test results, lab reports, emails about DNA testing, analyst bitch notes, communication with DPS. They are just personal identifiers, safety, protected employee info. Should you appeal this? No, not right now. It says appealing driver's license and social security numbers, home addresses, personal. It says will not help you uncover when the DNA was tested, whether the results changed, when Adam Vincent analyzed the evidence, whether retesting occurred. Those redactions are not where your case lives. It says your case lives in the DA's internal communications, DPS lab timelines, analyst notes, which are currently pending AG ruling on the other two tracks. What this tells us strategically, this confirms your request reached multiple agencies, records are being processed, routine confidential info is being stripped out, substantive material may still be released. So this is part of the pipeline, not the end of the results. It says what you should do now. Review whatever records came with this letter. Look for dates, evidence transfers, DPS submission references, property logs, lab submission forms. Those often slip through and show when the kit was sent to DPS. Do not appeal these routine redactions. File anything with the AG on this one. Spend time fighting over personal data. It won't move the forensic timeline forward. Big picture status. It says status. Hold on, source and status. So court saying a medical received, GPD partial routine redactions, DA's office, AG ruling pending, DPS crime lab, AG ruling pending. Says the scientific timeline is still coming from DPS, AD communication, DA communication. Next big move, if the city provide evidence logs, property room records, submission forms, upload those because those often show date kit left GPD, date DPS received it, cause numbers tied to lab submissions, which starts narrowing when Vincent could have touched it. You're progressing exactly the way these cases unfold, piece by piece. So y'all, this is just the beginning. We got to get into the letters, and it's a lot. I'm going to put that out here. Y'all just bear with me, man. Like I said, be ready for part 2.